Michael Gellert, a local attorney. What you're about to watch is jury review. Jury review is usually held a few days before jury selection and is the last opportunity for the court to determine which cases will be tried in the following week. And it's also the last opportunity for defense and the state to possibly come to an arrangement to where trial can be avoided and a plea bargain arranged. It's also the last opportunity where state may choose to drop or change some of the charges.
Scared of me.
Mr. Scott, if you'll unmute your microphone, Chris Scott. Hello, Mr. Scott.
Right.
Okay, private counsel?
Judge.
Ready, Mr. Flowers?
Judge.
Oh, wait a minute, wait, we got Mr. Scott.
Okay.
So just hold tight. Mr. Scott, if you'll start your video. Well, we're getting there slowly, maybe. Mr. Scott, can you hear me?
I'm ready, Your Honor.
Good, thank you. Mr. Scott, I'm taking your case first because Mr. Wooden, I was informed that he refused to come down from the jail. You did see the email that was yesterday afternoon, correct? Regarding the evaluation of Mr. Wooden? Mr. Scott, did you see that?
Judge, I'm having a little bit of a hard time hearing you. I can hear you, but it's coming through a little bit muffled. I apologize.
Okay, no, not a bit. Is that any better? Not really. Okay. Do you all have a microphone close to a speaker? Or do you have your mic up? Okay. Let's see, Mr. Scott. We'll see if we can get it better. Good. How about now, Mr. Scott? Is that better? Nope.
Much better. Thank you, Judge.
Okay. So, Mr. Scott, did you get the email yesterday from Psychiatric Associates that talked about Mr. Wooden?
I did not get that email. I might have received it, but I have not reviewed that email.
Okay, so here's what it says. From Psychiatric Associates from the doctor, it says, after speaking with Judge Brown, I was informed that Mr. Wooden does not have an attorney as he is representing himself. Mr. Scott has been appointed as standby counsel only and will not be actively involved in the case unless Mr. Wooden decides that he does not need representation. I'm sorry, that he does need representation. Although the Assistant State Attorney, Michelle Reed, informed you in an email dated 9/13/23 that Mr. Scott would be contacting you, this was incorrect and the review needs to go forward at this time. Please let me know how quickly this review can be completed and if you need further information from me in order to get this accomplished. So it sounds like that the state told the doctor that that Mr. Scott would be scheduling the evaluation, and that's what slowed down the doctor.
Your Honor, I've never spoken to the doctor. I'm not sure who spoke to him, and my name's Michelle Sandler.
I know, and it was interesting, it said Michelle Reed.
I have no idea. I have no emails with him, no communication with him, haven't had any phone calls, anything. So I'm not sure who he spoke to.
Okay. So hopefully Dr. Zeman will do the evaluation. If you don't mind, if you'll double check with Dr. Zeman next week.
I absolutely will, Your Honor.
Good, thank you. So that was the delay in evaluation. Mr. Wooden said that he's not going to come down, so we'll continue his hearing until January 8th at 9 o'clock. Mr. Scott, thank you so much for acting in this role. I know it's difficult. As you know from my order, when I looked at the range of possibilities for a standby counsel, I've seen that courts have done all kinds of different things with standby counsel. I just don't think it's fair to standby counsel to say basically you're going to be the paralegal for the defendant. And so that's why I take the position that you're in the wings, and then if the defendant says, I need counsel, then you step in full-fledged representing that defendant. So thank you for taking on this role.
Thank you, Judge.
Yes, sir. Happy Thanksgiving.
Thank you, you too.
Thank you. Okay, now, Mr. Flowers.
Good morning, Judge.
Good morning, sir.
Your Honor, I was appearing, the defendant's name is Shropshire, Judge,
Okay, yes, sir.
and I believe the state is
So
going to make...
we were hopeful, set it for today. I wanted to speak with the alleged victim in the case, and I was unable to do that yesterday. I made a couple attempts, so I'm not in a position to agree to, we're in negotiations still, but I needed to speak with the victim on the case.
Okay.
And that didn't happen, so I was hopeful.
Okay, what's that case number?
The case number is 2023 CF 2014.
Got it. Yes, sir. It's under Mr. Shaw's name.
Yes, sir.
I did see that the defendant's appearance was waived, so are we just going to keep it on for January 8th?
Yes, sir.
Okay. Mr. Flowers, I'll see you then.
Very well, Judge. Have a good Thanksgiving. Thank you,
too.
sir.
Thank you,
And
sir.
that's another one that we were talking about the other day. Hopefully, maybe we can bring it in December. So,
Okay.
And if we can, we'll, of course, cooperate with the state. If we can do that early, we'll do that, Judge.
Sounds good.
Thank you, sir.
Yes, ma'am. You ready, Ms. Reed?
Yes, I am. Hi, good morning, Judge. How you
Morning,
doing?
ma'am. Good. How are you?
Good. I am appearing for Mike Gates, who represents Mr. Guy Santucci. That is 23 CF 644, and Mr. Santucci is here. Yeah, come on up.
Good morning, sir. Good to see you again.
Judge, first thing, I would, if it is okay, I have a proposed order modifying bond. Basically what happened earlier this week with Mr. Santucci, with him getting arrested, even though there should have been an order modifying the contact provisions of the bond. I just wanted to make sure that the court record and the case file was clear, so I do have a proposed order modifying bond that allows Mr. Santucci to have no violent contact with the alleged victim, and he may return to his residence. I've provided a copy to Mr. Snell before court this morning. He's had the opportunity to review the language, and he has no objection. Is it okay if I approach?
Yes, ma'am. Please,
Okay.
Mr. Snell.
I spoke with Ms. Santucci yesterday, and that's her wishes.
Thank you.
So,
Okay, good. Thank you, ma'am. Okay, Mr. Santucci, I'm signing that order now, okay?
Thank you.
Yes, sir.
And as far as the case, Judge, this case was set for trial. However, the defense and the state have entered an agreement for pretrial intervention with a plea that's going to be a plea as charged with sentencing deferred. The terms of the pretrial intervention will be 12 months with a significant amount of special conditions. I do have a copy of the signed plea as well as the referral to pretrial intervention that has been signed also by my client and the state. May I approach?
Yes, ma'am. Thank you.
Thank you.
Thank you, ma'am. So, Mr. Santucci, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand out.
Thank you.
So, Mr. Santucci, it's a little unusual that pre-trial and then have a plea agreement. So what that means is that if you fail to fulfill the requirements of pre-trial intervention, then you could be sentenced up to a total of 6 years, 5 years in prison, 6 years in prison. Do you understand that?
Yes, sir.
Okay. Did you read the plea agreement? Did you read the plea agreement?
No, sir.
No.
Okay.
I do.
And I want you to read it, okay? Because it's really important. It's all your rights. If you'll sit back in the gallery, read
Yep.
through it, and then I'm going to ask you if you understand it and talk about it a little bit, okay?
Okay.
Yes,
Please
sir.
read.
Yep. Okay.
Thank you.
Thank you.
Yes, sir. Ms. Jacob? Good morning, ma'am.
Neither of my defendants are here yet, and I'm, with my office being closed, trying to get a hold of someone to check to see if any voicemails have been left. So if I can just pass for a few minutes.
You let me know when you're ready. Okay, I don't think we have any pro se's. So to the public defender, Mr. Kleins, welcome back.
thank you, Your Honor.
Yes, sir.
Your Honor, I'm Daniel Ledoux. This is Mr. Ledoux, Your Honor. He is present. We remain ready for trial. I can tell the court, I know I've been out the past couple of days. I don't expect any unusual motions in limine, and I don't expect there to be any issues with the jury instructions. I would expect these are going to be standard instructions throughout. So I guess we just need to schedule the trial.
Okay, what day do you want to schedule it for?
I would request next Wednesday.
That's good with the state, Your Honor.
Okay. So Wednesday at 8:30, that is November 29th.
Yes, sir. And I would expect, we just need a regular 22-member panel. I think we'd be fine with a pick and go.
That's correct. Yeah, I think we'd be done in a day pretty easily.
Okay. So, Mr. Ledoux, that means I'll see you back here next Wednesday, the 29th at 8:30, and then we'll pick the jury and get going with the trial, okay?
Yes, sir.
Thank you, sir.
I'll give you a call on Monday morning, okay? All right. Have a good Thanksgiving.
Okay, who's next?
Your Honor, I was talking to Mr. McKinney. I believe Mr. Martinez Echeverria may be on Zoom. I don't.
He's not on
He's-
Zoom.
If we could pass Mr. Martinez Echeverria.
Yes, sir.
The only other one I have on the morning docket, Your Honor, is Crystal Owen. And if we could put Ms. Owen's case on the afternoon docket. I've been providing Mr. Gomez some emails that Ms. Owen has sent me today, ostensibly showing proof of payment. That's kind of, once proof of payment has been shown, I believe the state would announce a dismissal, but I would like to give Mr. Gomez time to review those emails.
Okay. Yes, sir. Mr. McKinney?
Judge, I have Ms. Malkia Turnage, 23 CF 237. She appeared via Zoom on docket day on Monday. The court instructed her to be here in person.
Yes, sir.
I have called for her in the courtroom today for 23 CF 237.
Ms. Turnage is not on Zoom. There's nobody in the waiting room. It's just the Zoom cart and me on Zoom. She was ordered to be here today at 9 o'clock. It's now 9:14. A no bond capias is issued for Ms. Turnage.
And Judge, I have one inmate. May I pass that for just a moment as I'm preparing a plea agreement?
Yes, sir. Okay. Do you want to get Mr. Koch? Tell him we're ready for him? To the state, did y'all see the October 30th email list of expert witnesses? It has Christopher Beltran, Stephen Edney for adult and juvenile competency evaluations. Also, Theodore Williams. Have y'all seen those names?
No, sir, we haven't.
Okay. And then Dr. Klein. Okay, well then I'll get that forwarded to y'all and also send it to the PD just to make sure.
Your Honor, is that, just so that I'm aware, is that kind of experts that we can try to get appointed other than Dr. Zeman?
Absolutely,
Okay.
yes, sir. Do you know if Jerry Mays is still an inmate? Yes, ma'am. 21 CF 1932. He went. Good, excellent. Okay. Good, because I had heard and never saw, I didn't see the minutes for November 16th. So that there wasn't an order in for a bond. I told him he was out. I'll just keep, I just wanted to make sure you wasn't waiting on that because the minutes didn't show up. Neither did I.
I think we can recall Mr. Santucci.
Good, thank you.
Great. Yeah, come back up. Okay. Mr. Santucci has had the opportunity to review the applicable language within the standard plea and sentencing agreement and is prepared to answer the court's questions. May I approach?
Yes, please. Mr. Santucci, you're still under oath, okay?
Yes, sir.
Thank you. So, Mr. Santucci, did you read the plea agreement?
Yes.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did she answer all of your questions?
Yes, sir.
Are you satisfied with the representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Okay. So, Mr. Santucci, the way that I started that, was the maximum. I always want you to know the maximum downside. Pretrial intervention is a diversion program. It diverts around the court. So if you successfully complete it, what happens to your case?
Just dissolved.
Right, it's dismissed, so it's gone.
Thank you.
So I wish you the best, Mr. Santucci.
Thank you so much.
Thank you, sir.
Okay. All right. You're good to go. You can go home, okay? Yeah. Well, you'll probably need to check in with probation. Okay. Yep. So I'll. You're good. Yeah. Go with probation, okay? And Judge, that concludes my business before the court may be
Yes, ma'am.
excused.
If you'll approach.
Yes, absolutely, Judge.
Thank you. Okay, you want to grab it? Thank you.
Thomas.
Yeah, probation needs a signing form.
Okay? Yes, we're closed until Monday. Okay, thank you.
But so he was released even though, yeah. Are you talking about Jerry Mays by chance? Okay. Yeah. Sure. Sounds good. Thank you. This proposed order says came on November 6th.
So when I,
As long as he's out, that's what you talking about. I'm not just signing the order, I mean, any indication that we ever done.
Gotcha.
Okay, thank you. It just bothered me because I thought he said, you know, wait, Thank you. Mr. Koch.
Good morning, Judge.
Good morning, sir.
Mr. Gomez, I know he's on this case. Did he just step out?
He's on a video call. He said he'll be back in just a couple minutes.
Do we want to address this, wait till Mr. Gomez comes back?
What are you seeking regarding Mr. Polson?
This would be a change of plea, Your Honor.
Okay.
And I do have a signed
Has,
plea form from the state and my client. Everyone
Good.
has signed it.
Then
but-
I'm ready.
But there's just one stipulation on credit time because my client was served with warrants.
Okay.
I was just going to ask Mr. Gomez if we could stipulate to the date of arrest of April 20th, 2023 for all cases.
Got you.
And then, in the meantime, if we can, I can enter the plea.
Sure.
Thanks,
Okay.
Judge.
Good.
I have my client, Mr. Polson, to my left here, Your Honor. We're in 23 CF 878, 23 CF 911, 23 CF 920, 23 CF 1057. Be a change of plea of no contest, Your Honor. And in 23 CF 920, counts 2 and counts 3. And also in 23 CF 1057, count 1. Client will be adjudicated guilty, be 22 months, Department of Corrections. All cases and counts are unconcurrent. Credit for all time served. There's $450 in defense cost, $2,160 in court costs, Your Honor. And in case number 23 CF 878, that's counts 2, 3, and 4. And in 23 CF 911, count 2. In 23 CF 920, count 1. My client will be adjudicated guilty and credit for time served. If I may approach, Your Honor, with the plea form and the score sheet.
Yes, sir. Mr. Paulson, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you can put your hand down. So, Mr. Paulson, in contract language, we say a condition precedent. Something has to happen before other things are required. So all of this, the condition precedent, if you're saying that you don't want to enter this plea if the state doesn't agree to your credit for time served starting April 20th of this year, then all of this will be for naught, and we won't know that until Mr. Gomez comes back in. So let's go through everything with the condition precedent that the state will agree to credit from April 20th of 23.
Yes, sir.
Okay?
And Your Honor, if I may, I apologize. I typed that on my computer, of course. I also left out to announce on the record, but there is reserve restitution for 90 days. That is on the form now. I just apologize for not stating that.
Okay. Mr. Polson, let's start with that. Do you agree to the court awarding restitution, but reserving jurisdiction to determine the amount of that restitution? In other words, you're agreeing that you're going to pay the restitution whenever, if the court decides what that is, and we'd have a hearing on that. It wouldn't happen without you being present, and your attorney arguing for a lesser amount, presumably, and the state saying, here's what it is, and then the court would have to make a determination of actually what the restitution is.
Yes, sir.
Okay. Did you, I'm sorry, are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No, sir.
How far did you go in school?
I graduated from high school.
Good. Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Mm-hmm.
Is that a yes?
Yes, sir. Sorry.
Did you sign the plea agreement?
Yes, sir.
Are you satisfied with Mr. Koch's representation?
Yes, sir.
Mr. Gomez, now that you're back, do you agree to Mr. Paulson receiving credit for time served starting on April 20th of 23?
Yes, Your Honor.
Okay.
I verified I verified beforehand that was when the time started tolling. And just for the record, I had spoken with the victims on this case to make sure that they were good to go. And there is some outstanding restitution that we will be seeking, but we will set a hearing for that, Your Honor.
Okay. Mr. Paulson, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you, and are represented by competent counsel with whom you state you are satisfied. I find that there is a factual basis for acceptance of the plea. You're adjudicated guilty in each case and count. You're sentenced to time served on the misdemeanor counts. You're sentenced to 22 months with the Department of Corrections with credit for all time served, beginning no later than April 20th of 23. Again, it's concurrent. All the sentences run at the same time. You'll need to pay the attorney's fees of $450, public defender's fee, all monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. And the court does award restitution if the state files a petition or a motion within 90 days from today. Okay.
Okay.
Thank you, Mr. Paulson. Good luck to you, sir. Yes, ma'am. Thank you.
Excuse me.
Yes, sir.
Yes, Judge, I have Mr. Kevin Ponti, P-O-N-T-I, and this is two cases on the docket, Judge, 22 CF 2981 and 23 CF 395.
Yes, sir.
Your Honor, just to be brief, my client wants to accept the 22 case. There's a plea offer. My client wants to enter a no contest plea. But we also want to resolve the 23 case. And just briefly, in that case, there is the alleged victim. There was a depo that she failed to show. Speaking with the state, and I'll let him explain, that if we could set this for December, give the state time to reach out to the victim in the 23 case, and on that date, enter a plea because a global for everything.
And the reason, and Your Honor, I was speaking with Mr. Koch, I think if, like we were discussing Monday, if there is a date that we end up figuring out that can work between the next week or two, then we'll set it for that. I just candidly hadn't spoken with the victim in the newest 23 case, because I was kind of just focusing on the trial for the 22 case. Now that we've kind of come to an agreement on that, we haven't actually had contact with the victim in the new case, so I want to make sure that I kind of do my best efforts to establish contact with that victim. And then if I can get up with her and we can come to a resolution, then we'll bring it in as soon as next week or the week after if we come up with a date for pleas. But at the worst case scenario, bring it in on like December 11th, I think would be the first date that we have available to set for an entry of a plea to all the cases.
Okay. So Mr. Ponte's not entering any plea today?
No, Your Honor, I think he was ready to plead to everything, but I need to do my due diligence with Marcy's Law on the victim on the new law case and make sure that I exhaust all possible us trying to get a hold of her. And then once that happens, we'll be in a position to resolve the 23 case as well. I think he agreed that we could do a plea on the 22, but we would rather have a global resolution if possible, so we're not adjudicating him, sending him to DOC, and then bringing him back just to enter a plea on the new
Okay,
23
so
case.
what, assuming that the victim, you either can't get in contact with the victim or they agree to the sentence, what is your offer to Mr. Ponte?
So if they agree, if we can't get in contact or they agree to the sentence, the belief is that the victim is not wanting to prosecute this case. If they do, that drops off 2 of the charges in the 23 case. That would reduce the score sheet down to approximately 30 points, in which case Mr. Ponte would be willing to enter a plea into that. I just need to make sure
So what would the sentence be?
adjudication of guilt, 30 months in the Department of
30
Corrections.
months, okay.
Yes,
I thought you said points, okay.
sorry, 30 months, yes, Your Honor.
Okay.
I meant, yeah, the lowest permissible points would be 30, would be around 30, so it would be a 30-month Department of Corrections sentence.
Mr. Ponte, if the alleged victim agrees, or if the state can't get in touch with the alleged victim, is that something that you think that you'd be willing to accept?
Yes, sir.
Okay. The reason why I ask that is, if you say, Judge, I'm not going to take that no matter what, then I'd want to go to trial on this one case. So that's the reason.
Yes, sir.
With you saying that, Mr. Ponte, then the motion for continuance is granted. So I'm going to schedule both of your cases for January 8th. It'll just be the pretrial. But if, do you want me to also schedule it for a plea on December 11th?
Yes, Your Honor, I think that would be the best bet to do. I think at the latest, we'll get it in by then. If we can come up with a date amongst the state attorneys to have one person available for a day of pleas like we talked about, then,
Yes,
and I can get my contact with the victim or lack of contact with the victim established by then I'll make sure that it's scheduled for that plea day that we choose.
Okay. So, Mr. Ponte, I'll see you on December 11th at 9 o'clock.
Yes, sir.
Okay? Thank you, sir.
Thank you, sir. Appreciate it.
Yep.
Thank you.
Yes, Judge. Judge Vorot, do you need a moment? May I have just a brief moment, Judge?
Yes, sir.
Case is going to trial or due.
Oh, that's right. Yes. Okay. I just want to make sure that it was. Judge, if I just have one brief more moment, just a correction that was made.
But I just didn't want to be the person that someone off for probation. Tell them it's happening. The due one will be interesting because.
And then,
Did you ever?
1932.
Yes.
Okay, great. Thank you so much.
You're welcome.
Thank you.
thank you. And I just to show you, I just had them initial there.
Yeah, for the change.
Yes, sir. All right, thank you. Yes, Judge, thank you for
Yes,
that
sir.
moment. Your Honor, we're here on 2 cases, the 2019 CF 1817, which is violation of probation, and then the 23 CF 929, the new law, Your Honor. In the 2019 CF 817, count 1 and count 2, it'd be omit, revoke, terminate the probation. There's the $100 cost of prosecution, and then the 150 defense costs. In case number 23 CF 929, count 1 and count 2, Your Honor, adjudicated guilty, 7 years, Department of Corrections, and both counts run concurrent. Credit for all time served. There's $1,140 court cost, $100 defense cost. And Your Honor, there's the $50,000 fine for the count 1 and the additional $50,000 fine for the count 2. And in 23 CF 929, count 3, client will be adjudicated guilty and credit for time served. And on the plea form, Your Honor, I did have my client initial on the corrections that were made from the state, just to, because I went over with them.
Good.
May I
Thank you.
approach with the plea
Yes, sir.
form?
Thank you, sir. Mr. Rott, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Rott, are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No, sir.
How far did you go in school?
12.
Okay. Did you read the plea agreement?
Yes,
Do you understand it?
yes,
Did you discuss it with your attorney?
yes,
Did he answer all of your questions?
yes,
Are you satisfied with his representation?
yes,
Did you sign the plea agreement?
yes,
Mr. Rott, do you understand that if I accept your plea, that you're waiving your right to a trial by jury on the new case,
yes,
and you're waiving your right to an evidentiary hearing on the VOP case?
yes.
You have any questions for the court or your attorney or the state?
No.
Mr. Rott, when I asked if anybody's forced, threatened, or coerced you into entering the plea, has anybody done that?
That what now, sorry?
Has anybody forced, threatened, or coerced you into entering the plea?
No.
Okay. The opposite of that is, as Mr. Koch said, Mr. Rott, if you don't enter the plea today, you shall be sentenced to 30 years in prison or any other definite sentence.
Yes.
Okay? Do you understand that? What did somebody tell you? That you shall be sentenced to what if you don't enter this plea?
I would look,
Wait, but let me
Okay,
hear it
sorry.
from now. Yes, sir?
I would, the 7 years would get taken off the table, and then I'd get the full 25.
Okay. And you say then you will get the full?
Yeah,
Okay. Do you understand that the jury would have to find you guilty, and then it would come to sentencing for me, and I have no idea what I'd sentence you to?
right.
Okay. So, do you understand that if you do not enter the plea today, no one can tell you exactly what you'll be sentenced to if the jury finds you guilty, because I don't know what I'd sentence you to.
Right,
Okay?
yeah, I feel like I'm just being pushed into signing, really, because I don't really know him, like, because I had McKinney, and then I was just giving him just that Monday when I last saw you, this past Monday. So I didn't really get to sit down and really I just got all my paperwork just on Monday. So it's all thrown at me at once, so I only got like a 48-hour choice to choose to either pick the plea or take it to court, or take it to trial,
Yes, sir.
so,
Well, do you think that you've had sufficient time to consider it?
not really.
Because if you don't want to, I don't want to accept the plea, I'm not going to accept the plea if you don't want to enter it. We'll go to trial, I think that's what we're prepared to do. You've just got to decide what's in your best interest.
Right.
Listen to advice of counsel, but it's up to you to decide.
Right.
So if you think it's better to go to trial,
Well,
you
no,
know, then we'll
it's
do
not that
that.
I want to go to trial, I just wanted to continue, just to let this all sink in and get my ideas, and you know what I'm saying, because this was all thrown at me just on Monday, and then yesterday when I was able to talk to him, because this is my, only third time meeting my public defender.
okay, what was there ever an offer from the state that was close to 7 years?
No, this is the first offer ever thrown at me.
Okay. Mr. Snow?
Perhaps it'd be better if we approached the council and I could explain that to you.
Well, I want to make sure that Mr. Rott, I'm not concerned about anything other than Mr. Rott really knowing what he's entering into and he decides to do that. So I don't think, I'm concerned about the appearance of us talking behind Mr. Rott's back.
Makes sense.
You know. Mr. Rott, do you want us to pass your case until this afternoon and you think about whether you want to enter it or not? Because I'm not going to continue the trial. You know, I'm not going to continue the trial, so you need to decide today.
Right.
Okay.
Yeah, no, I mean, if there's nothing I can really come out onto, I'm just gonna sign, yeah.
Well, do you want more time? We can do it this afternoon. I assume the state would hold it open until this afternoon, correct?
Yes, sir.
Okay.
Yeah, no, I'll just,
Are you sure?
yeah, because, I mean.
I'm
yeah.
sorry, what?
No, that's fine, yeah, I'm fine, I'm sure,
Okay, so you want to enter the plea?
yes.
Okay. You think it's in your best interest to do that?
Yes.
Mr. Rott, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you and are represented by competent counsel with whom you state you are satisfied. I find that there is a factual basis for the entering of the plea. Okay. Well, isn't 7 years, that's 94 months, correct? So we're doing a downward departure of a month, 1.1 month?
Yes, sir.
Okay. Mr. Wright, you're adjudicated guilty in each case and count. Your prior supervision is revoked and terminated. You need to pay the $100 cost of prosecution, total of $250 public defender's fee. All monetary assessments mandated by statute or county ordinance are imposed. That's the court costs on the new case. All financials will go to a civil lien or judgment. You're sentenced to time served in count 3 of 23 CF 929. You're sentenced to 7 years with the Department of Corrections with credit for all time served and to run concurrently, run at the same time. You'll need to pay a total of $100,000 fine. Again, that will go to a civil lien or judgment. Mr. Wright, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, sir.
Thank you, Mr. Wright. Got you. Mr. Koch? Mr. Koch, there's no mandatory minimum on these, correct? No mandatory minimum?
That was why they did the 7-year period, was right at that 90 is exactly 70.
Okay, so the answer to my question is, there is a mandatory minimum?
Yes, sir.
Mr. Koch, you got to tell me that up front.
Okay, yes, Judge.
So you wait until the end to tell me there's a mandatory minimum?
Judge, I apologize.
Really important.
Yes, Judge.
If you were Mr. Wright, wouldn't you want to make sure that, you want to make sure that the court knows that, where Mr. Wright knows that? Are you finished? Okay. Mr. Wright, if you'll come back to the lectern a moment. So, Mr. Wright, everything that we just did will be torn up and it'll be, we won't enter the plea if you don't want to enter it. I was just informed of an additional term. You may know about it, but I want to make sure you know about it. So how long is the mandatory minimum?
Judge, on the trafficking, the fentanyl case, it's 7 years, and the count for the trafficking methamphetamine is 3 years, mandatory minimum.
Okay. So what that means to you, Mr. Wright, is that it's a 7-year mandatory minimum, which means you're going to serve day for day 7 years. You don't get any gain time.
Oh, see, I didn't know that. That wasn't told to me.
Okay, so you don't want to enter the plea today?
Do get game time.
You'll get game time. You'll get game time.
He's going to get gain time with a mandatory minimum? How does that work?
I believe that's, we looked it up.
Your Honor, I can tell the court, it's been quite some time since I talked to the Department of Corrections official about this, but the last time that I talked to the Department of Corrections, the information that I received was that the department is going to award game time on any sentence that does not statutorily require 100% of the sentence to be served. So in other words, the department's position generally is the court has to sentence somebody, in this case, to 7 years. It's not going to affect their ability to accrue game time. It just means that the court cannot give them anything less than 7 years, but the department will treat that as just any other 7-year sentence. Unless the statute specifically says, like for example, firearm or felon in possession of a firearm, that statute specifically says that a defendant sentenced under that statute has to serve 100% of the time. The department's position the last time I talked to them was, if there's no language like that in the statute, then the individual will be entitled to gain time. If they just treat it as the court has to give them that minimum time.
Okay, first time I've heard that, so I appreciate that. Okay, so Mr. Wright, I was wrong. You will get gain time. If you, and I'm putting this, everything's on the record, everything's recorded. If you find out that you do not get gain time, then you decide whether you want to try to overturn this or not, whether you want to appeal it, okay? Because on the record, I'm telling you, you get gain time, okay? So that's preserved for you, okay?
Okay.
Thank you, sir. Good luck to you.
Thank you.
Thank you, Mr. Klein.
Yes, sir. And I also always tell clients, hey, you're entitled to gain time until you mess it up. So until you earn it, it's speculative.
And, Your Honor, just for the record, the state did research that issue this week, and that we concur with Mr.
Good.
Klein's.
Well, thank you. I always tell folks I get paid to learn, so I appreciate it. Thank you. Yes, sir, Mr. Koch.
Judge, can I just have a brief moment?
Certainly.
I know she looks like it's.
So after this guy, I have to get back on Zoom for that. Only one that I think I have left on the docket is this guy.
And just for the record, still no one has tried to attend or join in Zoom, and it's 9:47 a.m.
For the second week.
Thank you, Judge.
Yes, sir.
Your Honor, this is Mr. Willie Patterson in 23 CF 1261. Today, we're here for trial or plea, Your Honor. My client wants to enter a plea to the bench if we can secure the soonest date possible. I told him that we need to put everyone on notice and to prepare to argue a downward departure and possibly drug offender probation, what my client is seeking. He's accepted in a Keaton house, so I'm going to bring the documentation. I need some time to prepare for that argument. So,
Okay, and let me just stop you a second. Mr. Patterson, I'm smiling because I did read your letter, and I highlighted, I talked to the director of Keaton, and then, you know, that certainly gives the court another option, and so I did read your letter.
Yes, sir.
Good. Okay, hold on one second. Let me finish with Mr. Koch, and then I'll talk to you. Yes, sir.
and, you know, I did confirm on my end that he is accepted into Keaton, and that will be part of my argument, of course, when we plead to the bench on that.
What does his score sheet show?
Judge,
17.55 months is the lowest permissible prison sentence in the Department of Corrections, Your Honor.
Thank you.
And he is facing a possible exposure of a total of 10 years, 5 years on each count.
Okay. Yes, sir. Mr. Koch. So, Mr. Patterson wants to plead straight up? Is that what you're saying? What are you stating?
if Your Honor, yes, to reject the state's offer and plead to the bench, but if I get a date just for that hearing.
Sure. Okay. A date for that hearing. So you want to plead straight up, and then we have a hearing on the sentencing?
Yes, Judge.
Okay. Do you have an agreement that's signed by Mr. Patterson?
I don't, Your Honor.
Okay. Because this is so important, you need to do a written plea agreement. Mr. Patterson, I want you to understand that although the sentence won't be imposed today, I want you to understand what you're giving up, your right to a jury, what possibly you'd be sentenced to, even though the state said a total of 10 years in prison. The plea agreement will say the maximums. I just want to make sure that you understand all those things, and I want to talk to you about it, okay?
Yes, sir.
So, Mr. Koch, if you'll do a written plea agreement?
Yes, Your Honor. If I may have a moment.
Well,
Bring
Mr. Patterson's going to have to read it, so
I would just recommend bringing him back this afternoon, Your Honor.
let's do that. Mr. Patterson, I'll see you this afternoon, okay?
Thank you.
Thank you, sir.
I'm going to hand this to you. Actually, I'll bring a new copy to you back there.
Judge, this is Mr. Sean Tillman before the court. Mr. Tillman has a total of 3 cases, and we set 22 CF 1348 and 18 CF 2512, which are felony violations of probation, over to today to enter a plea in those cases. The intention from the parties here is for us to enter the sentence for the VOPs today, for us to continue the underlying offense, which is not set for trial, for entry of a plea on a separate date, which would have a separate score sheet for a concurrent Department of Corrections sentence.
Okay.
So in 22 CF 1348 and 18 CF 2512, Mr. Tillman has reviewed this document in the back. Do you have any questions for me?
No, sir.
Okay, so you need to sign it today. The agreement with the state calls for Mr. Tillman to admit the violations of probation. In 22 CF 1348, Mr. Tillman is on supervision for a misdemeanor. That would be time served, revoke and terminate probation with a $100 VOP, $150 cost of defense. In 18 CF 2512, Mr. Tillman would be sentenced to an adjudication 52.2 months Department of Corrections with credit for time served, revoke and terminate his probation, $100 VOP fee, $100 cost of defense. There is prior DOC credit in that case number that he would be awarded. And then the intention in 23 CF 1697 would be to continue that case until the 1/8 court date, and then we will set that for an early plea in December. May I approach?
Yes, sir. Thank you, sir. Mr. Tillman, I hesitate because it's unusual to enter a plea this way. So, Mr. McKinney,
The reason being, right now the score sheet shows 52.2 months, Department of Corrections. After the court imposes sentence, as we've just handed to the court, then those cases will move to his prior record. And then in the score sheet for 23 CF 1697, even though this would likely be resolved with a Department of Corrections sentence, he would not score prison at all.
Okay.
Because everything would move from the additional offenses down to prior record.
Okay. Mr. Tillman, I wanted to understand, because, you know, you, under the new case that you're not being sentenced to today, he could be sentenced up to 5 years, though,
Correct.
right?
Correct.
Okay. So it would change his score sheet.
Dramatically.
But not the maximum he could be sentenced to.
Because right now, the most serious thing is what he's on probation for from 2018, the burglary of a dwelling. And that is, since it's the primary on the score sheet, is why the score sheet reflects 52.2 months.
Okay.
After this moves from the primary offense down to the prior record, then the new score sheet in 23 CF 1697, he won't even score DOC at that point in time, even though that is going to be the state's offer for a concurrent DOC sentence.
Even though that's going to be the state's offer.
Correct. The agreement with the state is for us to structure the sentence this way.
So what is the agreed upon sentence for the new case not to be imposed today? What is that?
12-1.
Judge, we've said, we've proposed 12-1 as a Department of Corrections sentence.
Concurrent?
That is, yes, Judge, concurrent.
Okay, is the state agreed? I'm just trying to make sure that Mr. Tillman
Mhm.
knows
I
the
understand.
deal.
I
And also
understand.
put it on the record, because again, it's very unusual. Otherwise, I'm gonna go through a colloquy with Mr. Tillman and say, do you understand you could be sentenced up to 5 years in prison on the new case, even though you're entering the plea today?
And Judge, I believe that's the appropriate conversation to have with Mr. Tillman, because we're not entering that other plea today. The state can make and revoke offers at any time. But the intention in the discussion between the parties at this point is for us to enter the plea agreement on the violation of probation, and that it would not be a county jail or a probation sentence. It would be a DOC sentence for the 23 CF 1697. He would not score DOC on that case the way that we are doing this. But tentatively, what we've proposed is a 12-1 for that case to be resolved.
Okay. Mr. Tillman, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
Thank you, sir. You can put your hand down. So, Mr. Tillman, did you understand everything that was stated today on the record, Mr. McKinney and the court?
Yes, sir, I did.
Okay. Did you read the plea agreement?
I did, sir.
Do you understand it?
Yes, I do.
Did you discuss it with your attorney?
We did.
Did he answer all of your questions?
Every single one of them.
Are you satisfied with his representation?
Absolutely.
Did you sign the plea agreement?
Yes, sir, I did.
Are you currently under the influence of any drugs, alcohol, or medication?
Not currently, no.
Okay. Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
And no, sir.
Okay. Never been treated for that in the past?
No, sir.
Okay. Mr. Tillman, how far did you go in school?
I got my GED.
Okay. Mr. Tillman, so you understand on the case that you're not being sentenced to today, the new case of 23 CF 1697, you could be sentenced up to 5 years in prison.
Yes, sir, I do.
Still wish to enter the plea?
Yes, sir.
Mr. Tillman, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you, and are represented by competent counsel with whom you state you are satisfied. I find that there is a factual basis for acceptance of the plea. You're adjudicated guilty in 22 CF 1348. Your supervision is revoked. You're sentenced to time served. You'll need to pay a $100 cost of prosecution, $150 public defender's fee. In 18 CF 2512, your supervision is There we go.
Is this him? No, this is Rogers.
Mr. Cobb, can you hear me?
Yes, I can.
Excellent, thank you. Mr. Cobb, so Mr. Roberson's here. What do you wish to do with Mr. Roberson's case?
Yes, Judge, you appointed me on the 8th of November. I'd like to just move it to January 8th so I can have time to speak with Mr. Roberson and look at the case and see what we can do with it.
Okay. Mr. Roberson, I'll see you back here no later than January 8th.
Okay, thank you.
Thank you, sir. Thank you, Mr. Cobb. Thanks for appearing so quickly. I know that you filed a notice of appearance. I appreciate that.
All right, thank you, Judge.
Happy Thanksgiving.
You too, Judge.
Thank you. Okay. Yes, sir, Mr. Klein.
Your Honor, I talked to Mr. McKinney. I believe Mr. Martinez Echeverria may possibly be on Zoom. I don't.
No, nobody's on Zoom other than the Zoom card.
I will presume that the court gave Mr. Martinez Echeverria notice to be appearing today on Monday.
We did. We actually waived what we specifically cited, and the court can correct me if I'm wrong, is we were talking about whether or not we wanted him to be present in person today. And we agreed on it would be okay, him showing up, because he lives 8 hours away. We would be okay with him showing up on Zoom today.
Yes, sir. And I don't see him on Zoom. So what is the state seeking?
KPS, Your Honor.
Because we were,
Can we wait until the afternoon session? Because the only reason why I say that is we have scheduled flights with the victim who lives in Baltimore. And so I want to give this every opportunity for him to appear so that we don't have to issue a KPS and restart this the next cycle, because we literally just got the confirmation of the itinerary this
Okay.
morning, so.
so we'll continue it until 2:30 this afternoon.
Thank you.
What I will do, just so the record is clear, Your Honor, is I have 4 different phone numbers for Mr. Martinez Echeverria. I called all of them last week and left messages, and he did not return a phone call. I will try to call him again today at all 4. None of these numbers are his direct number. They're people he knows. So I will make the phone calls again. I'm not going to hold my breath that I can get him on the phone today.
Thank you, Mr. Klein.
Thank you.
Okay, who else? Mr.
That's the case that we were going to ask to put on the 1:30 docket. I had provided Mr. Gomez some emails, and I need to talk to him and see what the state is.
I just need some time to review those emails, Your Honor.
And as far as Martinez Hectavarius, we'll just do it at 1:30 versus 2:30.
That's fine.
Thank you, Judge.
The difference between 1:30 and 2:30 is not going to change whether I get him on the phone.
I understand. Okay,
The Thomas or James Owens,
I don't see Mr.
for status.
Mr. Owens' case.
Judge, I did see that Mr. Owens had filed a formal notice of appearance, probably a not guilty plea.
Right, he did. He filed a denial. So it's set for January 8th at 9 o'clock.
Kevin McNamara with Mr. Nopes. I should have used
I believe Mr. Nopes, I had discussed with Mr. Nopes. Mr. Nopes, I believe, pulled Mr. McNamara in the back and is speaking with him right now.
They are in the attorney-client room. They're wrapping up now.
Okay, good. There he is. Speak of Mr. Nopes. You ready? Mr. Nopes, you ready for your client?
I am, Your Honor.
Thank you. Hello, Mr. McNamara.
Judge, I'm here on Kevin McNamara's case, 22 CF 2289 and 23 CF 90. Judge, it's my understanding the state is not in a position, at this point, they've tried to contact the victim, but they're not in a position to change their current offer. So what I'm going to do is I'm going to file a motion to modify his bond in 22 CF 2789, and then I'm going to file in the 2390F a motion to modify those bonds that were set. I'm going to set it on your miscellaneous day, December 11th. I'm also going to file a motion to have a mental health expert appointed for mitigation purposes. I'll get all that done probably Friday, even though nobody's working, I'll be working. I hate Black Friday shopping anyway, so, but I'll get it filed, and then Mr. McNamara, next go-around, if we can't get it resolved, he wants me to set it for trial, next go-around.
The state agrees that is all accurate, Your Honor. I just, the last time that I had spoken with the victim, he was pretty dead set on moving forward with full prosecution. I haven't spoken with him in a couple of weeks, and so I think setting it on that 12/11 date would give me an opportunity to kind of get through this trial cycle and speak with the victim directly to see if there's any possibility of a lower offer being made to Mr. McNamara, and then if it is, we'll make it at that time and see if we can resolve the case.
Okay. Mr. McNamara, I'm going to just schedule your cases for the pretrial conference on January 8th as just a safety net. Hold on, Mr. McNamara. And also set it for a status conference on December 11th.
Okay.
So I'll see you back here on December 11th, okay?
Yes, sir.
Thank you, sir.
And am I good to notice December 11th for the bond hearing?
Yes, sir.
Okay.
Absolutely.
Very good.
Do you want it in the afternoon? Depends on the length of time. Why don't we set it at 1:30?
At 1:30, okay.
Yes, sir.
Very good, Judge, thank you.
Thanks, Mr. Noak. Does that mean you don't have to work on Friday?
I'm working Friday.
Okay.
No, I got to get all this stuff typed out.
Understand. Yes, sir.
I tell you what, it's really, practicing law, I've decided, is a bunch of little tasks, but there's a lot of them. You know what I mean? It's not all that complicated to do the little things, but when you multiply it by 20.
Right, the volume is brutal. Yes, sir.
Thank you, Judge. Y'all have a great Thanksgiving.
You too. Ms. Jacob?
Your Honor, if I can recall Kendall Schumacher.
Yes, ma'am.
Your Honor, case number for the record, again, is 23 CF 1338. Mr. Schumacher is going to be pleading no contest. The agreement is a withhold adjudication, 1 year probation. There's $40 per month cost of supervision, $610 in court costs, a $150 cost of defense. He does need to submit to substance abuse evaluation and complete any recommended follow-up treatment, complete 24 hours of community service work. As to count 2, it'll be a withhold and a year of probation concurrent. May I approach?
Yes, ma'am. Mr. Schumacher, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can put your hand down. Mr. Schumacher, did you read the plea agreement?
Yes, sir.
Do you understand it?
I do.
Did you discuss it with your attorney?
Yes, sir.
Did she answer all of your questions?
Yes, sir.
Are you satisfied with her representation?
Yes, sir.
Did you sign the plea agreement?
I did.
So, Mr. Schumacher, we had a lot of discussions before this. You know, I ask the question frequently, and it stops a lot of people. I don't say, are you happy with the plea agreement? I say, do you believe it's in your best interest to enter the plea?
No?
Okay. So do you want to go to trial? It's up to you. It's your case. I mean, you've got to decide what you think is in your best interest. If it's, again, I didn't say are you happy with it, but what do you think's in your best interest? If you want to go to trial, we'll go to trial. You know, it's your call.
I sit here and look at this court.
I'm sorry?
We're here for the best interest, right? For the people, for the people.
No question.
For the people. I made a mistake. No criminal history. None. 1 traffic ticket. And we can't come to an agreement to I'm losing school. I'm going to lose my future. Why? I made a mistake. But yet, that mistake is going to punish me for the next 20 years.
Yes, sir.
And I've been in this court, not the courtroom, but this courthouse. I've seen people come in, 10, 15 felonies, DUIs. It don't matter. I've seen the state, I've seen the defense, I've seen the people give people chances.
but I make one mistake, and we can't come to an, yes, the last month and a half, I have contacted Mr. Quett the best I can, but it's not out of choice. I sit here and I work, I go to school all day. Her office is only open a certain amount of hours. I can't talk to nobody at the state without her, and I can't talk to her without, what do we do? I mean, I'll take the agreement, but at the end of the day, I'm going to be punished further than what I should be. For someone that don't have a criminal record, that don't have a background, that's what I'm mad about. I made a mistake, I can admit it. But yet, I'm going to be punished further? What do I do? She don't have the answers. The state can't work with nothing.
Well,
I'm going
and
to...
that's, you know, Ms. Jacob and I have to play the hand we're dealt as far as from the state. We can't.
I know.
The court can't control what the state does, what they offer, what they don't offer. All I can do is promise you a fair trial in front of a jury if that's what you want to do. If you want to plead straight up, then it would be, the court would have to figure out what it thinks is a fair sentence. I have no idea what that would be. It may be better than what you're offered. It may be worse than what you're offered.
I just feel either way, I'm going to be punished further than what I need to be. I'm going to be punished outside of here.
I understand. The consequences that come from entering the plea.
It's just in general, just having these run a background. Just on a background, it's not even if I was found not guilty in the court, having these on the record is going to hurt me. It has already hurt me.
Yes, sir. What do you wish to do today, Mr. Schumacher?
I just want to get this behind me. I just feel like if I take the deal, then I just, either way, if I don't take the deal and I go to trial, I'm still going to be punished further than what I should be. And if I take this, I'm going to be punished further than what I should be. I'm losing a lot.
Yes, sir. It's a tough decision. Yes, sir.
Mm.
Do you wish to enter the plea today?
Is there a way there's no way the state and defense can talk? We can talk?
No, sir.
Nothing?
I think they've been talking for months.
All right, can I get a 48-hour continuance on this?
No, sir.
Okay, I have 30 days to appeal this, right?
You do?
All right, I will go ahead and, let me go ahead and sign this agreement.
Okay.
Go ahead and, I'll enter the plea in no contest and, enter this.
Okay.
And,
You already signed the plea agreement,
yep, let's
correct?
go. Go ahead.
Okay. So you wish to enter the plea?
I do.
Okay. Mr. Schumacher, I do accept the plea. Adjudication is withheld. You're sentenced to 1 year probation. You'll need to perform 24 hours of community service work. You'll need to submit to a substance abuse evaluation within 30 days from today, begin any treatment if it's recommended within 60 days from today. You'll need to pay the court costs, $150 public defender's fee, and $40 per month cost of supervision. That's on count 1. On count 2, adjudication withheld, 1 year of probation. That's to run concurrently, run at the same time. Thank you, sir. Probation?
Robert, if I could get his address, please?
Yes, ma'am. That's probation. She needs your address.
No, it's not the right. It should be confidential due to...
No, sir, it's not confidential.
Judge,
Can I have your address, please?
Judge, due to prior domestic issues, this court and the other court should
Mr.
have...
Schumacher, hang on one second. Your Honor, he does have an injunction in place with a young lady who is in mental health court at this time, based on him being a victim of domestic violence. So although probation will have access to his address, I would just ask that he be able to either write it down so that it's not on
Yes, sir. Yes,
the internet television that is being live streamed right now or announced on record.
Yeah, yes, ma'am. Absolutely. So if you'll just tell probation in private.
Your Honor, may I announce on the record that you'll be instructed to report to the office at 8 a.m. Monday morning?
8 o'clock Monday morning, you'll need to go to probation, okay? And they'll tell you where that is.
I understand. If the appeal's put in before that, do I still have to arrive at Monday, 8 a.m.?
Yes, sir, you do. You're on
Okay.
probation.
Okay.
Okay.
I just wondering.
Yes, sir.
Thank you.
Your Honor, those are my cases on the docket this morning.
Yes, ma'am.
May be excused.
Do you have anybody this afternoon? You
I do
don't?
not, Your Honor.
Because your office is closed.
Our office is closed, yes,
Yes, ma'am.
which has been made it very fun trying to get a hold of people.
Yes, ma'am.
Thank you, Your Honor, I
If
appreciate
you'll
it.
approach.
Yes, sir.
Yes, sir.
And if I just may have a motion from our client to sign,
Yes, sir.
Judge.
Yes, sir.
I'm gonna give the judge this score sheet.
Okay.
And then,
Yeah, I need
okay, thank you.
That's why I walked up here.
Is it 22nd? 22, 23. Thank you. I'll do that. Judge, may I approach with the score sheet and the plea form?
Well, give me the score sheet because we're offsetting sentencing, right?
Give it to you.
Yeah.
Okay.
I hold on to the score sheet until sentencing.
Okay. Yes, sir.
Mr. Patterson, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Patterson, are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No, sir.
How far did you go in school?
11th grade.
Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
So, Mr. Patterson, on the form, it says that you could be sentenced up to a maximum of 10 years in prison. Do you understand that?
Yes.
Okay. You
Yes,
sure?
sir.
It's not, I have no idea what I'll sentence you to. I mean, none at all, because I haven't heard from your side, I haven't heard from the state, but
If you just pay attention to the judge, I can.
Yes, sir.
Oh, yes, sir.
Okay, you okay? You understand the maximum sentence
Yes,
is
sir.
10 years in prison?
Yes, sir.
Do you still wish to enter the plea?
Yes, sir.
I believe that the state previously stated that the score sheet showed 17.551 months with the Department of Corrections. Is that accurate?
That is correct, Your Honor.
So, Mr. Patterson, have you had sufficient time to talk to Mr. Koch about what the court has to find in order to go to sentence you less than 17.55 months in prison?
Yes,
In other
sir.
words, a downward departure.
Yes, sir.
Have any questions for the court or Mr. Koch or the state?
No, sir.
Mr. Patterson, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you, and are represented by competent counsel with whom you state you are satisfied. I find that there is a factual basis for acceptance of the plea. When do we wish to set the sentencing?
12/11? Does that work for you?
Are
Let's
you
do
waiving
12.
a pre-sentence investigation?
Yeah, are you going to do a pre-sentence investigation or no?
December 14, 2:30? Judge, we'll waive the PSI, but the 14, 2:30.
Okay.
Just
So,
on
Mr.
track.
Patterson, I'll see you on December 14th at 2:30, okay?
Yes, sir.
Thank you, sir.
Yes, sir, thank you.
We off on that?
Yeah. 10-minute recess, and then we come back and do arraignments, correct?
Yes, sir.
Good, thank you.
Perfect.
All rise.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service
that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at DaceTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
What can I help you with?
I think I was bit by a vampire.
This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy?
Injured? Take a breath. Call Coy.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446. C&C Asian Market, located at 294 North Main Street in historic downtown Crestview, has the largest selection of Asian noodles, rice, and sauces in Northwest Florida. With more than 2,000 items on their shelves, you'll have no problem finding exactly what you need for preparing that authentic Asian meal. Open Monday through Thursday from 9 till 8, Friday and Saturday from 9 till 9, and Sunday from noon till 6 p.m. Be sure to check out our Facebook page for our weekly specials.
Pick and
Yes,
go one day?
pick and go.
Yes, Your Honor.
Yes.
Right.
Thank you.
Thank you. Okay. Mr. Koch? Thank you. Is that it? Okay, yeah.
I'm working on that offer.
Okay, thank you. Good, thank you.
All right, let me just get on the record. Judge, I'm here with Katrina Reno. There is the 23 CF 53 case, Your Honor, which is a violation of probation, and the 23 CF 2389 new law, Your Honor.
Yes, sir.
Speaking with the state, at this time, there's not an offer on the table, so I'll enter denial for the violation of probation, not guilty for the new law, Your Honor. If we can keep these together and set it for the 1/8 date
Okay.
of pretrial. And I did inform my client, when I do get an offer from the state, I'll convey it, and of course, we can set an earlier date.
Absolutely. Ms. Reno, I'll see you no later than January 8th, but if the state offers you something that you want to accept, Mr. Koch can set that for a hearing in the next few weeks, okay?
Okay.
Thank you, ma'am.
Judge, this is Ms. Silva. She's listed as no attorney, but the court appointed the public defender at her last court date. This is a fugitive from justice case, but she has signed the waiver of extradition, and the court has already had a 30-day review for Ms. Silva.
Yes, Your Honor, I'm just standing up because at this time, the state's going to be dismissing this case against her. Looking at the arrest date, it was almost 60 days ago. We held her for California. They didn't come and get her. We have no statute that allows us to continue to prosecute this case, and for those reasons, we would dismiss the fugitive from justice charge.
Ms. Silva, your case is dismissed, okay? So they'll release you today.
Thank you so much, Judge Ron.
Thank you, ma'am.
Thank you. You guys all have a wonderful Thanksgiving.
Thank you, you too.
Right, yeah, seriously, I'm leaving today. Okay, bye guys. Thank you so much.
Anybody else in back?
That's all we have on the 133 in custody.
Okay.
Other than Mr. Moore, who was just your client, has revisited.
Okay, right, we're going to bring him back. Okay. Before we break for lunch, you've heard me say to Venaries before, justice happens in this courtroom, and it has to happen in this courtroom. This empty shell of a courtroom isn't justice. Y'all are the ones that bring it to the public. On Thanksgiving, I would be very remiss without thanking you. It can't happen without y'all, with all your homework, with all you do, with caring about what you do, the passion that you have for your job and for your clients. So thank you so much from the court. We're in recess until 1:30.
All rise.